Hello viewers, as president, Donald Trump vowed to solely nominate socially conservative Supreme Court justices who embraced an originalist philosophy of jurisprudence, pointing to Justice Clarence Thomas and the late Justice Antonin Scalia as the type of justices he favored. Before we continue with this video, please take a minute of your precious time to hit the subscribe button and hit the notification bell for latest updates from us. Some right-wing Republican-appointed high court justices, though fiscally conservative, grew to become out to be socially liberal when it got here to troubles like abortion and others. For example, retired libertarian Justice Anthony Kennedy. Trump, however, wasn't searching for the subsequent Kennedy. Trump was once searching for the subsequent Thomas or Scalia. And the three justices he appointed, Brett Kavanaugh, Neil Gorsuch and Amy Coney Barrett, have been hailed by means of Fox News pundits as examples of originalism or textualism in action. But one media discern who is notably necessary of originalist or textualist ideology is Washington Post opinion columnist Ruth Marcus. In her December 1 column, Marcus slams originalism as painfully mistaken and warns liberal lawyers in opposition to shopping for into it. Liberal attorneys and liberal justices, for that count, number danger being caught in an originalism trap. Marcus explains. Originalism, the trust that that means of the Constitution used to be constant at the time it used to be adopted, is the prison concept that dominates the questioning of this conservative Supreme Court. Not all of the conservative justices are dedicated originalists. I rely 4 of the 6 all, however, Chief Justice John G. Roberts Jr. and possibly Samuel A. Alito Jr., who describes himself as a practical originalist. But they have all written or joined originalist rulings. Marcus continues, given that reality, liberals can't gently push aside conservatives' insistence that the Constitution have to be interpreted primarily based strictly on the authentic which means of its text. In the modern-day circumstances, liberal advocates acting earlier than the court would be remiss no longer to make an originalist case. But there's additionally little evidence, at least in the highest-profile cases, that it will do them tons good. According to Marcus, liberal lawyers who attempt to use originalist arguments to make their case are now not competing in a fair fight, however, rather, are up towards conservative justices who will cherry-pick competing originalist interpretations that comport with their underlying inclinations. The greater liberals' current originalist arguments, the greater they professional originalism alternatively than refuting it and providing a compelling alternative. Marcus warns. Courtroom advocates want to win the case at hand, but that undermines the greater necessary long-term effort to wrench the court away from its reliance on what is, at least as presently practiced, a wrong doctrine that peddles the phantasm of impartiality in the carrier of a conservative result. Marcus continues, because originalism purports to freeze our perception of the Constitution, as written at the give-up of the 18th century, or amended in the second half of the 19th, it is skewed to a cramped studying of the document, unleavened by using cutting-edge science and sensibilities. Why must we recognize a great deal, much less take delivery of the constitutional that means as constant at a time when ladies lack the proper to vote, when these days enslaved black humans attended segregated schools, when the financial system was once agrarian, and when the concept of homosexual rights used to be unthinkable? Originalism, in accordance to Marcus, used to be a fringe prison theory when it commenced to emerge in the early 1970s as a reaction to the perceived excesses of the Warren Court. And she urges liberal attorneys and judges to push back in opposition to originalism as a substitute, than pretending that a flawed approach has merit. Conviction, on the other hand, sincere, does now not make it incorrect approach, legitimate. Marcus writes. And the flaws embedded in originalism are magnified by means of its use or misuse through conservative justices and judges targeted on a favored outcome. This company of originalism isn't simply bunk, it's rigged, dishonest bunk. The extra forcefully liberal legal professionals and justices push again on it, the quicker they make their way out of the originalism entice the better. What is your honest view on this video? Drop your comments below and thanks for